Mary Ann says that her husband was diagnosed with silicosis a month ago. They're really struggling, and she simply would like to know if there's some legal avenues for them, since they were told it probably came from exposure at his workplace.
Mm-hmm. Mary Ann, as a general rule, that's going to be considered a workers' compensation claim and not a mass tort claim. Now, if there's some identifiable product at work that contributed to that condition, then of course, there would be a separate potential tort claim against the manufacturer of the product. You know, today there is a lot of litigation concerning talcum powder, and talcum powder being used by families for many, many years as being a source for the development of ovarian cancer and fallopian tube cancer and even mesothelioma. So, Marianne, you're right to question something like that. You're right to investigate it. And it would be a good idea that if you call our office or call another trial attorney's office, you could get good advice as to whether there's a potential third-party claim outside of workers' comp.
And Chase, let's dovetail on what Vic just mentioned. As Mary's been using that talcum powder really for most of her life, even with the kids when they were little, she's been diagnosed with some health trouble. Is it too late for her to join the talc lawsuit?
So this is very important for people to understand, okay? Because a lot of times they will see on the news that there's a huge settlement in a particular type of case, the talc case or the Ford Pinto case, something to that effect. And they automatically think that they are not going to be able to make a claim because the lawsuit is over. That is not the case, okay? And it's not the case for a very important reason. These types of things, that the types of illnesses or injuries that you develop as a result of using these talcum powders sometimes take years to develop. You may have used this talcum powder and it might be 3, 4 years, 5 years before you develop this cancer or it's detected. And then and only then would you have known that, would you know that you could possibly have a case against the manufacturer, Johnson & Johnson, of this talcum powder. And so in theory, the actual statute of limitations begins to run when you actually use the talcum powder. But there's something called the discovery rule, and that means that the statute of limitations is told. In other words, it doesn't start actually until you should have discovered that you have a claim that relates to this talcum powder. And so in most, like I think, again, most states, there's a statute of limitations associated with personal injury. Georgia, it's 2 years. South Carolina, it's 3. And so you will have 2 years or 3 years, depending on your situation, from the date that you should have discovered that this was an issue. Now, you have to also remember that if it's all over the news and everybody in the world knows and understands when you buy a Ford Pinto that it has this defect in design, and you go out and you purchase it, and then you blow up and get burned because of it, there is going to be a defense, called assumption of the risk. That's going to be in place, and the same is going to be true of the talcum powder. If you knew or should have known that this carried a very significant risk to cause you harm, and you continue to use it anyway, that is a defense that can either cut off completely any sort of award, or at the very least, degrade the award.